In Hughes versus Alexandria Scrap Corporation, we'll see whether a state law that treated in-state and out-of-state businesses differently violated the Commerce Clause. In 1969, Maryland created a law to get rid of abandoned cars. Under Maryland's state law, any person who had an inoperable vehicle that was over 8 years old, known as a hulk, could transfer the vehicle to a scrap processor. The processor could then claim a bounty from the state to destroy or recycle the hulks into scrap metal. The bounties allowed scrap processors to pay higher prices for the hulks, which incentivized more people to get rid of their cars. Initially, both in-state and out-of-state processors could receive a bounty if the processors provided proper documentation. However, in 1974, Maryland changed the law, and the state began requiring additional documentation from out-of-state processors, including a certificate of title or a bill of sale from a police auction. As a result, out-of-state processors needed to obtain more documents from parties that were selling hulks. After Maryland changed the law, it was easier for parties in Maryland to sell cars to in-state processors, which led to a drop in sales of bounty-eligible cars to out-of-state processors. Alexandria Scrap Corporation, a Virginia scrap processor, sued the state of Maryland, represented by Maryland's Secretary of Transportation Harry Hughes. Alexandria Scrap argued that the law unfairly burdened interstate commerce, in violation of the Commerce Clause of the United States Constitution, because the law imposed stricter documentation requirements on out-of-state processors compared to in-state processors. The district court granted summary judgment in favor of Alexandria Scrap. The state of Maryland appealed to the United States Supreme Court.